A contract breach typically occurs after one party fails to keep its part of the bargain. However, a breach can also occur before performance is due if one party signals an intention not to perform. This is known as anticipatory repudiation. And in National Farmers Organization versus Bartlett and Company Grain, the Eighth Circuit considered what type of statement constitutes an anticipatory repudiation. National Farmers Organization entered a series of 45 contracts to sell grain to Bartlett and Company Grain. Both parties fully performed under the first 31 contracts. However, starting with the 32nd contract, National began delivering late and incomplete shipments. In response, Bartlett began withholding a substantial portion of the payments due to National as protection against realized or potential loss caused by National's failure to perform under the remaining contracts. About a month later, with 8 contracts still due to be performed, National informed Bartlett that it would cease delivery on all the remaining contracts until Bartlett substantially paid for the prior deliveries. Bartlett treated this communication as an anticipatory repudiation and proceeded to settle its account with National. Bartlett calculated the amount it owed to National for the previous 6 partial deliveries and then set off this figure by the amount of damages caused by National's breach of these contracts and its anticipatory repudiation of the remaining 8. National objected to the set-off and brought suit to recover the alleged balance due. Bartlett responded that it was permitted to withhold damages related to National's anticipatory repudiation. National, however, asserted that its communication to Bartlett didn't constitute an anticipatory repudiation. The district court disagreed and found in favor of Bartlett. National appealed to the Eighth Circuit.